दोस्तों, आप लोगों का स्वागत है हमारे चैनल टेक्नोलॉज में। तो आज हम लोग बात करते हैं जुरिडिक्शन अंडर आर्टिकल 131। सो बेसिकली वी आर टुडे वी आर टॉकिंग अबाउट द ओरिजिनल एंड एक्सक्लूसिव जुरिडिक्शन। सो हम लोग आज बात करेंगे कि व्हाट डू यू थिंक इट इज द स्कोप ऑफ सुप्रीम कोर्ट जुरिडिक्शन अंडर आर्टिकल 131। सो अंडर आर्टिकल 131 के अंदर जो जुरिडिक्शन है सुप्रीम कोर्ट की, उसका क्या स्कोप है एंड किन केसेस को हम लोग सुप्रीम कोर्ट के सामने ला सकते हैं। The jurisdiction of the Supreme Court under Article 131 is not confined the dispute related to the specific or particular controversies, right? Article 131 confer original jurisdiction in any dispute. अब एंड लाइक हम बात करते हैं, jurisdiction is extremely wide in case of a dispute which concern any two state. Jurisdiction cannot be vested in the High Court to of any one or more state concern. The power held by the Supreme Court under Article 131 is not only original but it's also exclusive. So how it is, like, let's see. So however, even we discuss the exclusive jurisdiction of the Supreme Court, certain mandatory requirements are kept in mind in such as. So what is this requirement are? Let's see. So dispute must involve a question of law or fact which is existent or extent of a legal right, depends. Okay, thus purely political questions are excluded from the ambit of this jurisdiction. Second, private citizen cannot invoke the jurisdiction against the state or central. And third, the crucial expression in Article 131 is expression of legal right. And number four, this power under Article 131 is subject to the other provision of the Constitution, such that if a remedy of any issue is present under any other article of the Constitution, then this article cannot be invoked. सो अगर आर्टिकल 131 के सब्जेक्ट में अगर पावर किसी और आर्टिकल में है और वो इन्वोक हो सकता है, देन यू कांट गो अंडर आर्टिकल 131. ओके, सो व्हाट इज द डेफिनेशन ऑफ द स्टेट अंडर आर्टिकल 131? दैट इज आल्सो डिफरेंट. So the definition of the state under Article 131 is different from the definition of the state as under Article, like under Part 3 or Part 4 under Article 12. This issue came up before the Constitution Bench of in state of Bihar versus Union of India 1971 SSC 67. So this case में सुप्रीम कोर्ट के सामने ये इशू आया कि जो आर्टिकल 12 में डेफिनेशन है, आर्टिकल 36 में स्टेट की डेफिनेशन है, कैन द सेम डेफिनेशंस वी कैन यूज अंडर आर्टिकल 131. सो सुप्रीम कोर्ट ने, अब हम लोग इस केस के ब्रीफ फैक्चुअल बैकग्राउंड को जान लेते हैं और समझते हैं सुप्रीम कोर्ट में इसमें क्या अपैरेट किया. सो बिहार फाइल्ड मल्टीपल केस बिफोर द सुप्रीम कोर्ट अंडर आर्टिकल 131 इन द connection with delayed delivery of iron and steel material for its Gandhak project. One of the defendant in this dispute other than the union was Hindustan Steel Limited. So Hindustan Limited इसमें एक पार्टी बनाया गया. In all such cases, prayer of the plaintiff against the said defendant was that decree for the specific sum of money may be passed. Okay, so that's the remedy they are seeking for. Issue that arose for the determination. So there's a question of law which is comes in this case, whether the cause or cause of action in this suit are within the scope of Article 31, right? And second, whether the suit in within the scope of Article 131 of the Constitution in view of a non-state or Hindustan Steel Limited having been made a party with the suit. सो दूसरा क्वेश्चन जो था इसमें कि अंडर आर्टिकल 131 में क्या हिंदुस्तान स्टील लिमिटेड को एक पार्टी बनाया जा सकता है, वेदर द सूट इज बार्ड बाय द प्रोविजन ऑफ सेक्शन 80 ऑफ द सीपीसी. ओके, सो क्या ये सूट बार्ड होगा सेक्शन 80 सीपीसी के तहत? सो ये सब क्वेश्चंस ऑफ लाइक ये कोर्ट की डिटर्मिनेशन थी, ये इशू इसमें आए सामने. Then court decision revealed toward discussion. अब कोर्ट ने क्या रिफर किया? In this case, Hindustan Steel Limited was held not to be state for purpose of Article 131, since it is only include the actual state government and central government. The enlarged definition of state as under part 3 and part 4 of the constitution is not attract to article 131. ओके, सो यहाँ पे इन्होंने ये फाइंडिंग दी कि जो डेफिनेशन है आर्टिकल 131 में स्टेट की, वो अट्रैक्ट नहीं करती है डेफिनेशन जो आपकी पार्ट 3 में है स्टेट की, लाइक आर्टिकल 12 में जो डेफिनेशन दी गई है, that not attract in under this section under article 131. The court refer its previous decision in Rajasthan State Electricity Board versus Mohanlal 1967, and court ने इसमें कहा कि उस डिसीजन में in which categorically stated that the state board could be held the state under other authority within meaning of article 12. Therefore, appropriate direction could be given under article 226 and 227 of the constitution. Therefore, the court came to the conclusion that body like Hindustan Steel Limited cannot be state for the purpose of article 131 of the constitution. So एक आपकी चीज समझ में आएगी. And अब now we can discuss the limitation on exercise of the power under article 131. So क्या limitation under article 131? So by nature of the suit, like subject matter, that is the first कि किस नेचर और किस सब्जेक्ट मैटर के सूट सुप्रीम कोर्ट अंडर आर्टिकल 31 डील करेगा. सेकंड, विद रिगार्ड टू द पार्टीज whom can be the parties under article 131, and third, constitutionality specific exclusion. So there are the limited players so that the unnecessary dispute are not bring within the jurisdiction of the Supreme Court, since under this article court become the court of the first instance. So because under article 131 is the original jurisdiction of the Supreme Court, and only the original suit is instituted under article 131. So Supreme Court have used such limitation in the article 131. So first of all, we are talking about the nature of the suit subject matter. With regard the nature of the subject matter of this dispute, also certain limitations are placed on the invocation of the original jurisdiction. The wording of the under article 131 with regard to the nature of the dispute are as below. If and insofar as the dispute invoke any question whether the law or fact or which is existence or extent to the legal right depends. So dispute with regard to the political issues and any other dispute will not be entertained by the court by invoking its original jurisdiction. So Supreme Court ने इसमें क्लियर किया कि under Article 131 they are only dealing with the question of law or fact, and they are not going to deal with any political issues or any other issues. So they are not going to entertain. So that is the subject matter, they are going to deal with it. And second, with regard to the parties, following dispute are barred from the scope of Article 131. A private citizen cannot invoke the jurisdiction of the court against the center and state. So एक प्राइवेट सिटीजन नहीं इन्वोक कर सकता सुप्रीम कोर्ट की जुरिडिक्शन apart from the like center or state government. The crucial expression of the Article 131 is the expression legal right. This expression has the effect of excluding all controversies, including only non-legal issues, from the jurisdiction of the court. In jurisprudence, legal right is generally understood to be the immunity against the legal power of another. So the power of the court under Article 131 is subject to the provision of the Constitution, such that if a remedy to any issue is present under any other article of the Constitution, then this article cannot be invoked. Okay, so this is all. And now constitutionality specific exclusion. There is two specific category of the constitutionality specific exclusion. One being exclusion specific in the provision of the Article 131 itself, and another being the exclusion specific in Article 262. So Article 262 क्या बात करता है? Article 262 एक तो exclusion लगाता है कि these matters are not going to be covered in the Article 131, and then Article 262 is also defined. Article 262 of the Constitution expressly exempted such dispute from being tried by the Supreme Court. It is fact not barred the jurisdiction of the Supreme Court, but of all the courts. और ये नहीं है कि सुप्रीम कोर्ट को ही बार करता है, इट्स बार ऑल द कोर्ट. नो एनी कोर्ट कैन deal such kind of dispute that is barred under Article 262. So Parliament may by law provided for the adjudication of any dispute or complaint with respect to the use of distribution or control of the water or any इंटर रिवर और रिवर वैली. सो अगर ऐसा कोई डिस्प्यूट है तो पार्लियामेंट लॉ बनाकर उस डिस्प्यूट को डिसॉल्व कर सकती है, खत्म कर सकती है. बट लॉ लाइक जुडिशरी और आपका सुप्रीम कोर्ट, जो कोई भी कोर्ट इसमें इंटरफेयर नहीं करेंगे, इंटरवेंशन नहीं करेगी. अगर कोई रिवर के पानी का डिस्प्यूट है या रिवर वैली का डिस्प्यूट है, नॉट विद स्टैंडिंग एनीथिंग in this constitution, Parliament may by law provided this, neither the Supreme Court nor any other court shall exercise jurisdiction in respect to any such dispute or complaint as is referred to the clause 1. So this is the Article 262, and I just want to let you know one case law. The Krishna water dispute between the state of Karnataka and the state of Andhra Pradesh. In this dispute also, Supreme Court held that like this is a dispute of water dispute, and like both the state amicably dissolve this dispute, they can make by the law, or like as it's a bar under Article 262. So thank you for watching the video. If you like the video, please like, comment, share, and subscribe the channel. Thank you for watching.